I do have skills that make me a nightmare for people like you.
24 minutes from Constellation.
G'day everyone. Right, just a quick little update as far as the $60 ticket's concerned. Yesterday at 9:30 in the morning, Philippa Chapman, Waitakere District Court, the court services manager, emailed me. Now, from back on the 25th of January, we had Selwyn Hayworth, Justice of the Peace, had me enter a formal plea. Then he set a date for the 18th of March for me to show up. Not that I had to be there, it was just a semantical thing, but I had to show up, and on the 18th of March, just to get a date set for a justice, for a judge. So 18th of March, so we start again. 25th of January, I see a Justice of the Peace. He sets a date for the 18th of March for me to be put in front of a judge to then ascertain a date for a judge-alone trial. So yesterday, the 13th of March, I get an email from Philippa telling me that an opening has happened. Now this is at 9:30 in the morning, telling me there's an opening this morning if I would like to come in for a possible 1 to 2 hour judge-alone trial. To which I no thank you to. Reason being is it would have taken me an hour to get in there. I wouldn't have been there till 11. So would have just, you know, perhaps they're just trying to fucking toss me off and juke me around. Then she said that the 1st of April, I don't know if this is whether she's trying to make an April Fool's out of herself in Waitakere District Court, but on the 1st of April, that there is a time slot for a judge-alone trial. However, depending on vulnerable witnesses and priority cases, I may not be seen until, you know, the end of the day type thing. So she wanted to pencil me in for the 1st of April. Now she sent this also to Vanessa Oliver, the Auckland Transport Prosecutor, and Vanessa said, yeah, no, that's fine, 1st of April, she can make that available and she can have the witness sorted. Brilliant. And however, as far as I'm aware, there should be an order, which I still haven't received, in regards to Selwyn and his obstructing of my rights under the Bill of Rights to seek, receive and impart information, opinions of any kind, in any form. In other words, for me to be able to record the court hearing. So they poo-pooed that. I still haven't received that order. Now, on page 2 of the transcript, on lines 6 to 8, we've got Selwyn not requesting, ordering that it be put in front of a judge, and this was in relation to section 363 of the Criminal Proceedings Act 2011. In that section, it states that a judge must give an order, or may give an order, to have the justices of the peace's matter transferred in front of a judge. Not the one with the lesser authority, such as Selwyn, pushing it over into a judge-alone trial, but the judge has to request the matter to be transferred. And I'm still wondering what grounds could it be that Selwyn's bias against me and couldn't be a fucking impartial judge in relation to the matter? I don't know. Perhaps that's why Selwyn decided to chuck it over in front of a judge. Perhaps it was an intimidation tactic to try and scare me, which it didn't. So, I emailed back Philippa yesterday in response to her "we can see you today" or 1st of April, and I said to her, well, why are we going to a judge alone trial straight away? The last I heard, the call over was for another hearing, and subsection 2 of section 363 of the Criminal Procedures Act states that the judge then dealing with the matter, after he's asked or ordered for it to be transferred over, shall treat it in the first instance, which means that not only by requesting the court hearing myself in the first instance, and that being deemed under section 21 subsection 6 of the Summary Proceedings Act 1957, it states that it shall be deemed a not guilty plea, the fact that I've requested a hearing. They then get me in January to enter a formal plea in front of a Justice of the Peace, only to be told, come back 2 months later, so you can be seen in front of a judge and set a time for a judge alone trial. So in other words, they need me in front of this next judge to enter a formal plea again, because I'm in a different jurisdiction. Now, the fact that the judge hasn't made an order for it to be transferred, which after a discussion between Philippa and an unnamed judge yesterday said I wouldn't be getting one, and then changed the tune and said she's going back to the judge to ask for one, because according to their rules and procedures and due process of fucking law, that's what's supposed to happen. Not just run it as you see fit. These rules and procedures and regulations are there for a reason. So, I've yet to be given the order from the judge asking for it to be transferred over, not because Selwyn ordered it to happen, because he doesn't have the authority to do so. And this is according to the prosecution's lawyer. This is according to Vanessa Oliver. If she hadn't brought this up, I wouldn't even know about it. However, if she's going to bring up a technicality in law, they best adhere to it, hadn't they? Or they wouldn't be following due process. So, as it stands, the 18th of March call-over hearing, where I'm supposed to be standing in front of a judge so they can get another plea out of me, which isn't going to happen. I will not be entering another fucking plea for any formal record, because I've already done so. And the reason they need to do that is so that the judge in his jurisdiction then has jurisdiction over this matter. He needs me to enter a formal plea under his jurisdiction. So, Philippa's getting back to me. She tells me the order from Selwyn is awaiting his signature. So go ahead, Selwyn. You go ahead and put your signature on the order that obstructs and infringes on my rights to keep a record of the matter, given that I'm a party and should be able to. And I don't mean just jotting down notes, I mean an accurate record, not one that can be altered and changed around like the transcription service tends to do, because I didn't say I have to come back to court, I said I love coming back to court, but that wasn't in the transcript. So, as it stands, it is now going to be the 1st of April at 9:30 in the morning, where I could be sitting there for up to 8 hours waiting to be heard, depending on priorities of other matters, because mine's just a lowly little Category 1 infringement offence for a speeding, for a parking ticket, which never existed in the first place because there was no offence, because of the conflicting road markings that AT then corrected. Philippa had the gall to turn around and say, because of the limited resources and strained resources, well, if Auckland Transport didn't fuck people around and try to frivolously and vexatious prosecute people for doing absolutely no offence, perhaps the resources of Ministry of Justice wouldn't be so tied up. It's not because I'm asking for a hearing, it's my right to. But they should have enough evidence and factual basis to file that prosecution, and they don't. So, because AT, Rick Bidgood, John Strawbridge, and all of the rest of the bigwigs that have refused to have a meeting with me, that will not discuss operational matters, not about my case, but the fact that they're out there dishing up tickets when they shouldn't be, because their engineering isn't up to scratch. And this has been confirmed by Auckland Transport parking wardens that have reviewed what I've showed them. resources wouldn't get chewed up so much, would they, Philippa? So, 1st of April, I'll be back. I'm going to make arrangements so I'm not paying 6 or 8 hours of parking while they get their shit together. The prosecutor has said, oh, it's only going to take 45 minutes. I've pointed out the last 2 Category 1 offences that I've defended have been between 4 hours and 5.5 hours, but they think they're going to be able to squeeze this all out in an hour? Good fucking luck. Because I've got quite a few, there's objections, there's evidence to determine the relevance of, or the authenticity of. There's lots of things that need to get sorted. So, will I get steamrolled by the judge? Will he just not have a bar of it? We'll see. But unless I get supplied some grounds for the reason for this was transferred over, I ain't putting another plea in the record, and they might go to section 39 or 41 of the Criminal Procedure Act 2008 and say, well, the defendant's refusing to enter a plea. Well, that's rubbish, because I already have done. I've entered a plea. It's just that I'm not going to be entering another plea in another jurisdiction just for these guys to get their shit right and then fail miserably at the end of it. Now, that's where I stand as far as when the next court date is. I may still go on the 18th of March because the granny biker chick, her judge alone trial is on the 18th of March, so I might go there just as a member of the public and view a public hearing, because I'm quite curious to see how this is going to work out for her. But anyway, coming up next, I'm going to be putting up some more videos in regards to the Official Information Act request. Now, I put 3 or 4 Information Act requests out there, and you'll find those quite interesting in the responses. But we'll leave that for another video. End of. Catch you later. I hope you're all doing really well and enjoying life, and we'll catch up with you. Till then, see you later.
Rainbows in the dark.
Cock it, let it go. Load it, cock it, let it go. Load it, cock it, let it go. Load it, cock it, let it go.